$2,140,000. That's what was sitting in a trust account with my name on it the day my father died. Money he built over 30 years running an HVAC supply company out of a cinder block warehouse in Ohio. Money he wanted to go to me, his only daughter, when I turned 25. I didn't see a dollar of it until I was 34. For 9 years, a woman named Diane, my father's second wife, my legal trustee, the woman who raised me from the age of 12, decided what I could and couldn't have. She decided if I could go to the college I wanted. She decided if I could take the job offer in Chicago. She decided if I needed a new car or if I was being reckless for wanting one. She decided if my wedding could be paid for, and then, 3 years later, she decided my divorce was further proof I couldn't be trusted with money. Every decision, for 9 years. And then, one Tuesday afternoon in March, sitting in a Panera Bread, with a folder of bank statements a forensic accountant had helped me pull together, I found the number that changed everything. Not $2,140,000. $412,000. That's what was left. Diane had spent 9 years telling me I wasn't ready for my own inheritance, and in that same 9 years, she had drained it by almost $1.7 million through shell LLCs, trustee fees she invented, and wire transfers to an account with a name I didn't recognize. They thought they got away with it. They were wrong. Hey, welcome back. If you're new here, this channel is about real financial justice. Stories about people who got scammed, stolen from, or controlled by someone who thought they'd never get caught, and how those people fought back and got every single dollar they were owed. Today's story is about greed. It's about betrayal dressed up as love, and it's about a young woman who was told for nearly a decade that she couldn't be trusted to run her own life, until she proved she was the only one in the family who could actually read a balance sheet. Before we get into it, if stories like this keep you up at night in a good way, hit subscribe, because we got a new case every single week, and trust me, this one has a twist in the final act that most viewers do not see coming. Let's get into it. My name is Sarah. I'm not going to use my last name or Diane's last name for reasons that will make sense later. There's an ongoing restitution order, and my attorney would like me to keep some details private. But everything else in this story is exactly how it happened. My dad, Tom, started his HVAC parts distribution company in 1988 with a used pickup truck and $11,000 he'd saved working as an actual HVAC technician. By the time I was born in 1990, he had 4 employees. By the time I was 12, he had 40, 3 warehouses across 2 states, and a client list that included half the commercial contractors in the Midwest. My mom passed away when I was 9, ovarian cancer. It was fast and it was awful, and for 3 years it was just me and my dad in a too-quiet house. When I was 12, my dad met Diane. She was a bookkeeper, and I want you to sit with that detail because it matters more than almost anything else in this story. She was a bookkeeper who did contract work for a handful of small businesses in our county, including, eventually, my dad's company. She was warm, she was attentive, she showed up to my school plays, she learned my favorite meals. Looking back now as an adult who has read a lot about how manipulators build trust, I can see the pattern clearly, but at 12, I just saw a woman who seemed to genuinely want to be there. They married when I was 14, and here is the first thing I want you to notice because it's a red flag so common in these stories that I guarantee some of you watching right now are nodding along, thinking of someone in your own life. Diane took over the family finances almost immediately. Not aggressively, not with some dramatic power grab. It happened the way water finds a crack in a foundation, slowly and through the path of least resistance. My dad hated paperwork. He was brilliant at sales, at reading a market, at knowing which contractor was about to land a big commercial job before they even knew it themselves. But bills, taxes, payroll, he found it tedious, and Diane was good at it. She'd been a bookkeeper. It made sense. By the time I was 16, Diane wasn't just managing the household budget. She was the company's full-time internal bookkeeper, working directly under my dad, with signing authority on two of the business's four accounts. I want to pause here and give you some numbers, because specificity is what makes fraud real instead of abstract. In 2008, my father's company, according to the tax returns I would eventually subpoena, had gross revenue of $6.2 million dollars and net profit of roughly $740,000. Diane's bookkeeping and office management salary that year was $58,000. Reasonable, market rate, nothing suspicious. That would change. My dad was diagnosed with pancreatic cancer in the fall of 2014. He was 61 years old. The diagnosis was stage 3, and the prognosis, even with treatment, was not good. He fought it for 14 months. During that time, according to records I later obtained, Diane restructured his estate plan twice. The first restructuring in December 2014 was reasonable on its face. My dad wanted to make sure the business could keep running if something happened to him and wanted to protect his assets from being eaten up by medical costs and probate. He set up an irrevocable trust, the Thomas Redacted Family Trust, and named me as the sole beneficiary. He named Diane as trustee because I was 24 and he trusted her, and honestly at the time, so did I. The second restructuring happened in October 2015, 1 month before my father died. This one added a clause that would become the single most important legal detail in this entire story. The trustee had sole discretion over the timing and amount of any distributions to the beneficiary until the beneficiary's 30th birthday, at which point the beneficiary should receive the full remaining balance, subject to trustee assessment of financial maturity. That word, should, instead of shall, and that phrase, subject to trustee assessment, would end up giving Diane nearly a decade of legal cover to do almost anything she wanted with my inheritance. My dad died on November 19, 2015. I was 25 years old. The trust, at the time of his death, held $2,140,000 in liquid assets, the proceeds from the sale of the company to a regional competitor, which Diane had actually helped negotiate and close just 6 weeks before he passed. At the funeral, Diane held my hand and told me, "Your dad built this for you. I'm just going to help you not screw it up the way he would have wanted it." I believed her. For years, I believed her. Here's how the control actually worked, because I think this is the part viewers relate to most. This wasn't a Hollywood villain twirling a mustache. It was death by 1,000 small denials. When I was 26, I got into a master's program at Northwestern. Tuition and housing would have run about $61,000 for the 2-year program. I asked Diane as trustee for a distribution. She said the trust wasn't liquid enough right now and suggested I take out student loans instead, loans I'm still paying off today, 6 years later, at 7.5% interest. When I was 28, I got engaged. My now ex-husband and I wanted a modest wedding, about $18,000. Diane paid for $6,000 of it from the trust and called it a very generous gift, more than your father would have approved. I never saw a bank statement. I never saw an accounting. I said, "Thank you." When I was 29, I wanted to put a down payment on a condo, $40,000. Diane told me, and I remember this conversation almost word for word because it's the moment I started to feel something was genuinely wrong. "Sarah, I've watched you make impulsive decisions your whole life. Your father asked me to protect you from yourself. I think renting another year is a responsible choice." I was a 30-year-old woman with a full-time job as a marketing analyst making $71,000 a year on my own, and I was being told by my stepmother that I couldn't be trusted to buy real estate with money that was legally mine, held in trust for exactly this kind of life decision. Every single year, Diane sent me a 1-page letter. Not a formal accounting, not a statement from the trust's financial institution, just a typed letter summarizing trust performance in vague terms. The trust had a modest year due to market conditions. Trustee fees and administrative costs are in line with prior years. I never once asked to see the underlying documents. Why would I? She was family. She had a professional background in exactly this kind of work. And frankly, I want to be honest about this because shame is part of how this kind of control works. I had internalized over 9 years the idea that I genuinely wasn't good with money, that I needed her. That belief is what Diane was counting on the entire time. The trust was supposed to fully distribute to me on my 30th birthday, per the 2015 amendment, the should subject to trustee assessment clause. On that birthday, Diane took me to dinner, told me she was still concerned about my financial maturity, given my recent divorce, and said she'd continue managing the trust for a few more years just to be safe. She had annual accountings prepared by an accountant. I'd later learn he was a longtime personal friend of hers, not an independent fiduciary auditor, that I never once asked to see in detail. I was 34 before I finally asked a question Diane could not spin her way out of. And that question is where Act 2 begins. The question that started everything was small, almost embarrassingly small given what it led to. I was refinancing a car loan in January of last year, and my lender asked for documentation of other assets to help with my rate. I called Diane and asked her to send me the current trust balance, not a summary letter, an actual current statement, because the loan officer needed a document with an account number and an institution name on it. Diane hesitated. For the first time in 9 years, she hesitated. She said she'd have to check with the accountant and get back to me. It took her 11 days to respond, which was strange because a legitimate, well-organized trustee should be able to produce a balance in about 11 minutes. When she finally called, she told me the trust balance was just under $600,000. I want you to do the math with me the way I did it, sitting in my car in a Kroger parking lot. $2,140,000 initial trust value in November 2015. 0 major distributions to me. The wedding gifts and a handful of small hardship releases totaled maybe $14,000 over 9 years. 9 years of market growth, even in a conservative moderate risk portfolio, should have added, not subtracted value. The S&P 500 alone returned over 150% cumulatively across that window, even accounting for the 2020 dip and the 2022 downturn. A trust that started at $2.14 million with almost no distributions should have been worth somewhere between $2.5 and $3.5 million by the time Diane told me it held just under $600,000. She was telling me that roughly $1.5 million, not including growth that should have happened, was simply gone. Her explanation, when I pushed, was a wall of vague language I now recognize as a classic pattern in financial elder and dependent abuse cases. Trustee compensation. The market's been rough. There were some bad investments your father actually chose before he passed. Administrative and legal costs of managing a complex trust. I did something that week I had genuinely never done in 9 years. I asked a lawyer friend from college, Priya, to look at my father's trust document, just casually over coffee. Priya read it twice. Then she looked up at me and asked, "Has anyone ever actually shown you a full accounting of this trust? Like, from the financial institution directly, not a letter from Diane." I said no. Priya put down her coffee and said, "Sarah, in the state of Ohio, a beneficiary of an irrevocable trust has an absolute legal right to demand a complete accounting from the trustee, including transaction-level records, at any time, not a summary, records." That night, I sent Diane a formal written request, Priya helped me word it, demanding a full accounting of the trust from its inception in 2015 to present, including all statements from the holding financial institution, all disbursements, all fees, and all investment transactions. Diane's response, 4 days later, was one paragraph. She said she found my sudden lawyering up hurtful and not what your father would have wanted from our family, and that she would, of course, provide records once the accountant has time, which she estimated would be sometime this summer, 5 months away. That delay was the moment I stopped being a daughter asking a question and became something else. I want to walk you through what I actually did next because I think this is the part of these stories that's most useful. Not just what happened to me, but exactly how an ordinary person with no legal or financial investigation background builds a real case. Step 1. I invoked my legal rights formally through counsel, not informally as family. Priya connected me with a trust and estate litigation attorney named Marcus Feld, who took the case on partial contingency once he reviewed the trust documents and my written request. Marcus sent Diane a formal legal demand under Ohio Revised Code, Section 580813, the statute requiring trustees to keep beneficiaries reasonably informed and to provide accountings on requests. This wasn't a request anymore. It was a legal obligation with a deadline, 30 days to produce a complete accounting or face a court petition to compel one. Step 2. While we waited on the legal deadline, I started pulling every record I could access on my own. Because I'd been named on some old joint documents from when I was a minor beneficiary, and because Ohio law gives beneficiaries certain rights to request information directly from financial institutions once a formal accounting demand is pending, I was able to request historical statement summaries from the brokerage that had originally custodied the trust assets, a regional firm called Cardinal Wealth Partners. What came back confirmed what I feared, and then some. The trust had held $2,140,000 in a diversified brokerage account in December 2015. By mid-2017, less than 2 years later, over $340,000 had already been withdrawn via a series of transfers to an entity called Meridian Bookkeeping and Advisory Solutions, LLC. I didn't recognize that name. Diane's maiden name was not Meridian. Her business, as far as I knew, was just her sole proprietor bookkeeping practice, which she'd continued running on the side after my dad's company sold. I searched the Ohio Secretary of State Business Registry, publicly available, free, took me about 4 minutes, and found Meridian Bookkeeping and Advisory Solutions, LLC, registered in 2016. The registered agent was Diane. The listed officer was Diane. The business address was Diane's home address, the house I grew up in. Diane had created her own company, a company that existed to bill advisory and bookkeeping services to the trust she controlled, and had been paying that company, herself, money out of my inheritance. Over the following 6 weeks, Marcus and a forensic accountant he brought onto the case, a woman named Renata Ibarra, who specializes in trust and estate fraud, pieced together the full picture using bank subpoenas, brokerage transaction histories, and Meridian's own filed minimal tax returns. Here's what they found, laid out the way Renata eventually presented it to me in a conference room with 3 color-coded binders. Trustee fees and Meridian bookkeeping invoices, 2016-2023, $612,000. For context, standard corporate trustee fees for managing an account this size typically run about 1% annually, roughly $21,000 to $30,000 a year depending on balance, or about $200,000 total over the period. Diane had billed and paid herself roughly 3 times the reasonable market rate through invoices Renata described as administratively unsophisticated to the point of being almost comedic, generic invoice templates, round numbers, vague descriptions like trust administration services, various. Unexplained wire transfers to an account at a bank Diane had never disclosed, 2018-2024, $487,000. This account, held at a bank 2 states away in North Carolina, was where things got genuinely strange and where Act 3 of this story really begins. Investment losses, real, but suspicious in scale and timing, roughly $210,000. Renata found that a chunk of the trust had been moved, starting in 2019, into a series of speculative microcap stocks and, alarmingly, into what looked like an unregistered private investment fund that had since gone completely dark. No website, no filings, nothing. Renata's professional opinion, stated carefully in her report, was that this pattern was consistent with either extremely poor fiduciary judgment or a vehicle for further undisclosed fund diversion. Total unaccounted for erosion of trust principal beyond reasonable fees and disclosed distributions, approximately $1,309,000. That's the number that turned this from "my stepmother made some bad financial calls" into something with a name: breach of fiduciary duty and very likely embezzlement. I remember exactly where I was when Renata read me that number out loud. Not the Panera Bread from the hook, that comes a little later in the story once the account details resolved further, but a smaller meeting in Marcus's office on a rainy Thursday. I remember my hands were shaking so badly I couldn't hold my coffee cup. Diane's initial attempts to resolve this, once she realized we were formally investigating, were, in hindsight, almost as revealing as the fraud itself. She called me crying, saying I was destroying this family over money that was never really mine to control in the first place, a genuinely strange thing to say to the person whose money it legally was. She sent a corrected accounting through her own attorney 3 weeks after our formal demand, one that retroactively reclassified about $180,000 of the Meridian payments as loans to the trustee, to be repaid with no promissory note, no interest terms, and no repayment history predating our investigation. She offered through counsel to settle the matter privately within the family for $500,000, less than half of what was actually missing, in exchange for me signing a release of all claims and a non-disclosure agreement. I said no. That refusal is what pushed Diane, according to what we'd later discover, to try covering her tracks more aggressively, which is exactly the mistake that made Marcus, Renata, and eventually a financial crimes detective everything they needed. Once I turned down Diane's settlement offer, everything accelerated on both sides. Marcus filed a formal petition in probate court to remove Diane as trustee and compel a complete forensic accounting, a legal process that, once filed, becomes public record. Once filed meant Diane could no longer simply stonewall or delay indefinitely. The court appointed a special fiduciary to oversee the trust's remaining assets immediately, freezing Diane's authority to move any more money. That freeze mattered enormously because it meant Diane could no longer touch what was left, the roughly $412,000 you heard about in the hook, while the investigation continued. I want to walk through how the actual detective work happened because I think it's the most valuable part of the story for anyone watching who suspects something similar is happening in their own family. The paper trail. Bank records, subpoenaed. Once the probate court granted discovery authority, Marcus subpoenaed full records from 3 institutions: the original Cardinal Wealth Partners brokerage account, Diane's Meridian bookkeeping business checking account, and, this is the one that broke the case wide open, that mystery account in North Carolina. The North Carolina account belonged to a bank called Piedmont Regional Trust. It had been opened in 2018 under the name Diane Redacted and Robert Holloway Joint Account. I had never heard the name Robert Holloway in my life. Renata ran a basic public record search: property records, court filings, business registrations, the same kind of free tools I'd used to find the Meridian LLC, and found that Robert Holloway was a 58-year-old man living in Asheville, North Carolina. property records showed he'd purchased a $340,000 house in 2019. Cash purchase, no mortgage recorded. Cross-referencing dates, that cash purchase happened 4 months after a $310,000 transfer moved from the trust's brokerage account through Meridian bookkeeping business account and into the joint Piedmont Regional Trust account. Marcus hired a private investigator, a retired financial crimes detective named Gail Okafor, to look into who Robert Holloway actually was. What Gail found was the twists that I promise you none of us saw coming, and I'm going to save the full reveal of what the money was actually funding for Act 4 because it deserves its own space. But I'll tell you this much now. Robert Holloway was not a business partner, not an investment advisor, and not, as Diane would later claim, a financial consultant helping manage trust assets more effectively outside of traditional markets. Witnesses and social media evidence. While Gail worked the Holloway angle, I did something that felt almost too simple to matter, but ended up being critical corroborating evidence. I went through 9 years of Diane's public and semi-public social media, cross-referencing dates against the financial timeline Renata had built. A Facebook photo from a girls' trip to Asheville, so relaxing, in June 2019, the same month as that $310,000 transfer. An Instagram post from 2021 showing a renovated kitchen with the caption, "Small treat for myself after a hard year of hard work." That small treat, based on receipts Renata later subpoenaed from the contractor, cost $84,000. A LinkedIn update from Diane's Meridian bookkeeping page boasting about expanding services to help clients build generational wealth through diversified alternative investments, written, we would learn, roughly 8 months after she'd moved trust money into that dark, unregistered fund. None of this was proof on its own, but it built a picture, sentence by sentence, receipt by receipt, that painted a portrait no jury or judge could look at and call just some accounting confusion. Working with law enforcement. At Marcus's recommendation, once we had Renata's forensic report and Gail's investigative findings assembled into a single package, we filed a formal complaint with the Ohio Attorney General's Consumer Protection Section and, separately, given the interstate wire transfers involved, a complaint with the FBI's Internet Crime Complaint Center and the U.S. Attorney's Office, since wire fraud across state lines, moving money from Ohio to North Carolina under false pretenses, is a federal offense that can fall under 18 U.S. Code Section 1343. I remember Marcus telling me, civil court gets your money back. Criminal referral is what makes sure this never happens to someone else. That distinction mattered to me more than I expected it to. An FBI financial crimes agent, along with a detective from the county financial crimes units, opened a joint investigation about 5 weeks after our referral. They interviewed Renata. They interviewed Gail. They subpoenaed additional records we hadn't been able to access as private citizens, including full transaction histories on the Piedmont Regional Trust account going back to 2018. Here's a near miss that still makes my stomach drop when I think about it. About 2 months into the criminal investigation, Diane's attorney reached out to Marcus with a new settlement offer, this time for the full $1.3 million paid over 18 months, in exchange for me not just dropping the civil suit, but also formally requesting the county prosecutor decline criminal charges, framing it as a private family financial dispute now amicably resolved. I was tempted. I won't pretend I wasn't. 18 months of guaranteed payments felt safer than an uncertain trial. My ex-husband, of all people, was the one who reminded me over the phone, she's not offering you money because she feels bad. She's offering you money because she's terrified of prison. I declined the offer, in writing through Marcus. I told him I wanted the truth on the record, not a quiet payout with a gag order attached. 2 weeks later, the U.S. Attorney's Office confirmed they were moving forward with a federal wire fraud indictment. That's when Robert Holloway, faced with his own potential exposure to conspiracy charges, agreed to cooperate with investigators in exchange for a more lenient plea arrangement. And that's when the full truth about the money finally came out. Let's start with the twist, because you've waited long enough, and because I think it reframes everything you've heard so far. Robert Holloway was not Diane's investment partner. He was not a financial consultant. Robert Holloway was Diane's boyfriend of 6 years, a relationship that began in 2018, roughly 3 years after my father died, and that Diane had kept completely hidden from me, from her extended family, and from the friend accountant who signed off on her annual trust summaries every year. The $1.3 million that had drained out of my father's trust hadn't gone into bad investments or reasonable trustee compensation. It had funded a second secret life, the $340,000 house in Asheville, purchased in Holloway's name specifically so it wouldn't show up in any search tied to Diane, an $84,000 kitchen renovation on that house, a joint brokerage account, separate from the Piedmont account, opened under a slightly misspelled version of Holloway's name, Robert Holloway, one letter off, which investigators believe was a deliberate, if clumsy, attempt to make the paper trail harder to follow. Vacations, a leased Mercedes, roughly $70,000 that simply couldn't be traced to any specific asset and was presumed spent on day-to-day lifestyle costs. Diane had spent 9 years telling a grieving, then confused, then increasingly self-doubting young woman that she couldn't be trusted with money, while funding a hidden relationship and a second household with that same young woman's inheritance. I want to be honest with you about how I felt hearing that, because I think it's more useful than pretending I felt only triumphant. I felt sick. I felt embarrassed, retroactively, for every year I'd apologize for asking about my money. And then, underneath that, I felt something harder and colder settle into place. The same feeling, I imagine, that a lot of you watching have felt when you finally got proof of what you already suspected. Here's how justice actually played out, in order, over about 14 months. The criminal case. Diane was indicted on 3 counts of federal wire fraud and 1 count of aggravated theft under Ohio state law, filed jointly by the U.S. Attorney's Office and the county prosecutor. Facing a potential sentence of up to 20 years on the federal counts alone, and with Holloway's cooperation testimony establishing clear knowledge and intent, he testified that Diane had told him directly, multiple times, that the money was technically my stepdaughter's, but she wasn't ready for it yet, so it's fine. Diane's attorney negotiated a plea agreement. She pled guilty to 1 count of federal wire fraud and 1 count of aggravated theft. She was sentenced to 4 years in federal prison, followed by 3 years of supervised release, and ordered to pay restitution. The restitution and civil recovery. This is where the numbers finally started moving back in the right direction. Through the criminal restitution order, combined with a parallel civil judgment Marcus secured in probate court, the following was recovered. The $412,000 remaining in the trust, already frozen and protected by the court-appointed fiduciary, was released back to me directly. The Asheville house, held in Holloway's name but purchased with traceable trust funds, was seized under asset forfeiture proceedings and sold at auction for $358,000, with the proceeds applied to restitution. The misspelled brokerage account, Robert Holloway, was frozen and its $190,000 balance recovered in full. Diane's Meridian Bookkeeping LLC, which had almost no remaining assets, was dissolved by court order, and any future business income for 5 years was made subject to a court-monitored garnishment toward the remaining restitution balance. The leased Mercedes was repossessed and the lease terminated. No meaningful recovery there, but it was formally documented as part of the total loss calculation for restitution purposes. Total recovered to date: $1,027,000 of the roughly $1,309,000 in unaccounted losses, about 78%. The remaining balance is being paid down through Diane's mandated prison work release earnings and post-release wage garnishment, structured over a 10-year restitution schedule, with Marcus's office monitoring compliance. Public exposure. Because the probate case and the federal indictment are both public record, and because Marcus felt, and I agreed, that transparency mattered both for closure and as a warning to others, the case was covered by our local news station and picked up by a regional business journal, focused on estate and fiduciary fraud. Diane's name, her sentencing, and the full scope of the fraud are now permanently part of the public record, searchable by anyone, including future clients who might otherwise have trusted her with their own bookkeeping or fiduciary work. My financial recovery. With the $412,000 direct release, plus my share of the restitution distributions as they've come in, I've now recovered roughly $980,000 net of legal fees. Marcus's contingency fee plus Renata's forensic accounting costs came to just under $180,000 total, which I want to mention because I know some of you are wondering what this kind of fight actually costs. It was worth every dollar. I finally bought that condo. I paid off my Northwestern student loans in full, $61,000 principal, plus about $19,000 in accumulated interest gone in a single payment that felt like exhaling for the first time in 9 years. And I did one more thing, which felt less like financial recovery and more like reclaiming something Diane had taken that had nothing to do with money. I set up a small scholarship fund in my father's name at the community college near where his warehouse used to stand, specifically for adult students studying accounting and finance, with one informal, unofficial requirement I mention to every recipient when I hand them the check. Learn to read your own statements. Never let anyone else be the only person who understands your money. I'm more vigilant now than I probably need to be, if I'm honest. I review every account I own monthly, not annually. I've become the kind of person who reads trust and estate law for fun, which is a strange sentence to say out loud. I don't think that vigilance ever fully goes away after something like this, and I've made a kind of peace with that. So, what do you actually do if you think something like this might be happening to you or to someone you love? Here are the warning signs, straight from what Marcus and Renata taught me during this whole process. 1. You've never seen a real accounting, only summaries. A trustee, a joint account holder, or anyone managing money on your behalf should be able to produce actual bank and brokerage statements on request, not a letter summarizing how things went this year. 2. Requests for basic financial information are met with guilt, delay, or emotional appeals instead of documents. That's hurtful that you'd ask, is not a financial answer, it's a redirect. 3. The person managing your money has created a separate business entity that bills the account they control. This is legal in some structured, disclosed, arm's-length circumstances, but it should always be fully transparent. With market rate fees, you can independently verify. 4. Your financial maturity is repeatedly used as a reason to delay money that is legally, unambiguously yours. Real financial protection has clear terms and clear endpoints. Indefinite, shifting goalposts are a control tactic, not a safeguard. 5, and this is the big one, if a trust or estate document was written or amended shortly before someone passed away and it hands broad discretion to one person over another, get an independent attorney to review it, even if, especially if, it feels disloyal to ask. If you're watching this and something in your gut just went cold because it sounds familiar, you have rights. In most states, beneficiaries can formally demand a full accounting, and trustees who refuse or stall can be compelled by a probate court. You don't need to accuse anyone of anything to start that process. You just need to ask, in writing, and put your own name on the request. I spent 9 years believing I wasn't capable of handling my own money. It turned out the only person who was ever actually bad at handling it was the one who kept telling me I couldn't. If this story hit close to home, if you've been financially controlled, scammed, or stolen from by someone who was supposed to protect you, I want to hear about it. Drop your story in the comments. You don't have to use real names. A lot of people in this comment section have been exactly where you are, and honestly, some of the best leads for future episodes on this channel have come from viewers just like you. Subscribe if you want to see justice like this every single week, and I'll see you in the next one.